latest in the Kejriwal bail plea case. The Delhi High Court has begun hearing the petition filed by the Enforcement Directorate against the bail granted to Arvind Kejriwal. The Delhi High Court had earlier halted the Rouse Avenue Court's order which gave bail to Kejriwal in the Delhi excise policy case. The ED has argued that the High Court in the High Court that the arguments from its side were not heard properly by the Rouse Avenue Court, and that it added that the judge did not even go through all the documents in the proper detailed manner. These are the latest updates we are bringing to you over this particular matter. Remember, earlier we had also brought to you the arguments that were presented to the High Court, to the Rouse Avenue Court before going to the High Court, in fact, by both sides, both Kejriwal's side as well as by ASG Raju. At this point, what we are seeing is Additional Solicitor General has accused the Rouse Avenue Court to have taken a hot and hasty decision. These were the exact quotes, the exact remarks that had come out in this particular matter. And this has come in after 2 whole days, mind you, ladies and gentlemen, 7 hours of the court having heard the case in detail. So why exactly is SV Raju making such claims? That is the question here. That is in fact the question that the High Court has also raised. They've also said that the ED seems to be a little biased in this particular case. Also, if we speak of the entire matter, there are arguments that's been placed by both sides, with SV Raju saying that there is evidence, while the other side has been countering that there is no evidence linking Kejriwal to the money trail.
एक अपराधी अरविंद केजरीवाल, जांच एजेंसी और माननीय कोर्ट, इन तीनों लोगों के बीच में सुनवाई चल रही है, मामला चल रहा है। कल जब एक कोर्ट उनको बेल देती है तो ये लिखते हैं सत्यमेव जयते, और आज अगर एक कोर्ट स्टे दे रही है तो इनको कानून बुरा लग रहा है। इन लोगों को ये समझना चाहिए कि शराब नीति में एक बड़ा घोटाला हुआ है। खुद न्यायालय कई बार इस बात को कह चुका है कि अरविंद केजरीवाल का इसमें भूमिका है। अरविंद केजरीवाल पूरे शराब नीति घोटाले के सूत्रधार हैं। तो जब इस तरह के आरोप लगते हैं तो जांच एजेंसी अपना काम कर रही है और न्यायालय ने निर्णय देना है। अरविंद केजरीवाल जेल भी न्यायालय के निर्णय से गए थे और बाहर जब भी आएंगे तो न्यायालय के निर्णय से आएंगे। तो ये मुझे लगता है जांच एजेंसी और न्यायालय को छोड़ देना चाहिए।
Well, with that, now let's cut across to our legal editor Ashok Bugaria, who's joining us from the newsroom. Ashok, currently we know the hearing is going on. Firstly, just bring us up to date with all that's been said so far in the High Court when we speak of this case.
Well, yeah, the hearing in the High Court has begun and the Enforcement Directorate is being represented by the Additional Solicitor General of India, Mr. S.V. Raju. Now, the main thrust of Mr. Raju's argument so far has been that, number one, the trial court conducted the hearing in a hot haste. The second thrust of his argument was that ED was not given an adequate opportunity to put aside its side of the story to oppose the bail, which was given by the trial court. So as far as the denial of opportunity is concerned, Mr. Raju is continuing to make his argument. He is saying that as far as Section 645 of the Prevention of Money Laundering Act is concerned, it mandates that the court hearing the bail application shall give an adequate opportunity to the public prosecutor to oppose the bail. And in this particular case, the lower court did not give an opportunity to the Enforcement Directorate to adequately put across its side of the argument. In fact, Mr. Raju also impressed on the High Court that just on this very ground, that the public prosecutor was denied an opportunity to put across his or her side of the view, this order must be stayed and a rehearing in this matter should be done by the High Court. Moreover, Raju has also impressed on the High Court that the High Court order is riddled with wrong facts and wrong dates. And he pointed out to one particular date where the lower court has recorded that the Enforcement Directorate was in possession of certain documents since July 2022 against Arvind Kejriwal, and he was called only for questioning in 2023. To which Mr. Raju pointed out that this is incorrect recording of facts by the trial court, because for the simple reason that the ECIR against Arvind Kejriwal or in the liquor policy scam was only recorded in August 2022. So there is no question of ED being in possession of any evidence or documents pertaining to the Delhi liquor policy scam in July 2022. Moreover, Raju has also been impressing on the High Court that there were certain documents which were presented by the Enforcement Directorate to consider by the lower court, but the lower court refused to look into those documents, saying that these are too bulky in nature. So the crux of the argument so far of Mr. Raju has been that just on two grounds. Number one, no adequate opportunity for the ED to present its case, and recording of wrong facts and dates are the grounds on which this order must be stayed.
Right. In fact, Ashok, if we look at the very first point that has been made by the ED's side, by SV Raju, we were discussing this only a little while back about how it's been 90 days that Arvind Kejriwal has been in custody, except for that interim bail period. And 2-day hearing, the bail order didn't just come out after a few hours. It was a 7-hour-long hearing that took place over a matter of 2 days. And after that, SV Raju coming out to say that they haven't taken the documents into proper cognizance, they haven't given them enough opportunities to present their arguments. I mean, at this point, the claim that's coming in that the ED might actually be biased in this entire investigation, do you think that does actually seem to be the case?
Well, no. That is what the lower court had recorded in its order while granting bail to Arvind Kejriwal, that ED was not acting without bias. But here, the ED is impressing on the court that this lower court order granting bail to Arvind Kejriwal is wrong, especially when the public prosecutor has not been given adequate opportunity and he was curtailed and cut short by the lower court in advancing the arguments to oppose the bail granted by Arvind Kejriwal. So Raju is basically telling the High Court that if we don't look at anything else but just look at the two facts that he is presenting to the court, that the mandate of Section 45 of the Prevention of Money Laundering Act, that the PP should be given an adequate opportunity, has not been given, and secondly, that there is recording of wrong dates and facts by the trial court in its order, are sufficient grounds to stay the order granting release to Arvind Kejriwal. But this is not the end of the argument. The arguments are still going on. Now, Arvind Kejriwal's lawyer are yet to argue this matter because it's just begun some 15 minutes back. It will take a couple of hours before the High Court actually makes up its mind whether to stay the release of Arvind Kejriwal or the High Court or the lower court order will continue.
Right, Ashok, thank you for bringing us all those details from the HC hearing now. Definitely quite a lot seems to be packed for this hearing, and quite a lot we expect at this point that might come out of this hearing. Whether or not, the question remains to be whether or not Arvind Kejriwal is indeed to get bail today. Is he to be released from Tihar jail today? Well, that is something that time will tell as the day progresses, and we'll keep bringing you all the latest updates with regards to this particular hearing that's ongoing into the case.